With respect, my lord, contrary to what my able-learned brother said, that this mic will not work because I'm not mic'd. So the mic is working. So, my lord, on a lighter note, I confirmed that the learned senior counsel informed me yesterday that it will be in court. And following the tradition at the bar, the defendant was not arrested. And learned counsel shows that the president, he was the former president of NBA, and brought him this morning. On a lighter note, I must appreciate him. That is a tradition that we met at the bar, and I pray that that kind of tradition will continue. However, the point I made, the learned counsel didn't come out well. I guess it's adjournment he wanted, because he's saying that adequate time and facility. My lord, the point I raised is not the role to be played by the defendant in any form. What I said, my lord, I want to state the fact in accordance with what the law says. So, and that will not in any way affect his presumption of innocence or issue of fair hearing or adequate time. Is when I state my fact, then he can proceed with his motion. So then, if he has any motion to pursue, because I believe that all those issues that he filed motion for have been raised orally, and the court has ruled on them. So, and they have even filed an appeal on it. The same point they took to Federal High Court, the same point at the Court of Appeal, the same point here. So, my lord, I want to say, my lord, that the fact that I state the fact will not take away his right to adequate time and facility to prepare his defense. We have served him more than 7 days. It is not true that he's hearing it for the first time today.
Yes.
So, my lord, it is not true that he's just saying the charge for the first time here. That cannot be true. That cannot be true. He has filed papers since last week on this charge. So, my lord, the right to adequate time and facilities, he has been given all the facilities. Even the fact I want to state are the facility that we gave to him. The proof of evidence, everything.
Yes.
The witnesses we want to call. So adequate time and facility that is guaranteed by the Constitution are supported by the rules of court and application of criminal justice law.
Yes.
So
by the intendiment of the Criminal Administration of Criminal Justice Act is to basically to effectively and efficiently dispense with criminal matters.
Within time, my lord.
Within time.
Yes,
so,
my lord.
The prosecution will be given opportunity to present.
And it's to be, and particularly section 396,
Yes.
It's supposed to be day-to-day trial.
Yes.
Where it is section 396, subsection 4, supposed to be day-to-day. So the issue of adequate time and facilities cannot arise. We are here now. He has gotten all the facts, he has gotten all the documents, he has been served with the proof.
Yes.
So, my lord, so that's my humble reply to what the learned counsel says. My lord, the issue of bail is taken for granted, because I will not stand here to oppose any bail. We are gentlemen. It's not even bail issue here.
The fact still remains that the defendant having brought himself before us voluntarily, we are not going to say he's not going to go back anyway. He is going back.
Yes, my lord.
We're not going to hold him. We're not going to ask for any search. We're not going to ask for any bail.
Yes, my lord.
He's on his own. He can go back and come back at the next time. But then, the most important thing for now is for the prosecution to, in line with the procedure under the commencement of trial before the tribunal, for him to present his facts. Do you have anything to say? But I'm also saying, that as an advocate, we are all ministers in the temple of justice, and we want to do justice not only to you, but also to the prosecution And whenever we do, we're doing it for posterity. So we must do what is right.
And they first of all do to us, because we are also entitled to justice.
Yes, certainly.
The point is that the Administration of Criminal Justice Act does not override the Constitution. It is the other way around. The Constitution says, give us adequate time and facilities to prepare for defense.
Yes.
Then we can come on date basis. I have not received any instruction. It will be highly prejudicial for him to go on with this.
Yes.
When I have cited the provision of the Constitution, it's in fact, I don't know what he would be talking about.
Okay, I'll ask out. It's okay.
So the point remains that we need time and facilities. We thank you for the direction on his liberty. All we are saying is that this is the time to go home. Let me take his briefing, and then we'll be here fully. Let's go for Salah and come back. My Lord, Barka de Salah in advance.
I think we have addressed these things sufficiently. I do not think that he has the right to dwell on that in his last address, because the Constitution did not define what constitutes reasonable time, adequate time. The times are prescribed by law, Administration of Criminal Justice law. They are the statutes that define what amounted to adequate time.
Yes.
So, my Lord, it does not derogate from the Constitution itself.
Yes.
So, whereas they came into hate. Constitution is a general principle of law that's provided that you must give adequate time. What constitutes adequate time? It's in accordance with the law. The law says these are the things we should do. Immediately after the plea, the prosecution should state his case. Immediately after that, he can then ask for adjournment. But for learned counsel to say that he has not taken instruction after he has filed papers, my Lord, he cannot say that he has not taken it. He cannot even be heard from senior counsel. A counsel filed papers since last Friday to say that he has not received instruction. My Lord, he cannot do that.
Prosecution
He cannot.
We'll give you the opportunity to shortly state the evidence you intend to prove of the guilt of the accused person. Just very briefly.
As the court pleases, my Lord. My Lord, the point which I'm obliged to do is that I'm trying to prove, my Lord,
Yes.
is that the defendant or the accused, as your rule says, he made 4 asset declaration forms.
4 asset declaration.
4 asset declaration form.
Yes.
My Lord, and it was those 4 asset declarations form that were investigated. He made one in 2003, 2 in 2007.
Let me take it.
Yes, my Lord.
He made a 4 asset declaration form, 1 which was investigated.
Yes, my Lord.
And 1 was taken in 2000.
In 2003.
In 2003. Yes.
Yes, my Lord. Another one was made on the 11th July 2007. 2007.
2007.
Yes, my Lord.
Yes.
He made the same asset declaration form, the 3rd one, in 2007.
In another 2007.
Yes, my Lord. That is, there are 2 asset declaration forms that he made
in 2007.
In 2007.
Yes.
My Lord, the final asset declaration he made was in 2011 June. My Lord, before this charge was filed, these are the only asset declaration form with the Code of Conduct Bureau.
Yes.
As at the time when this charge was filed. These are the only 4 asset declaration form. My Lord, in those asset declaration form, my Lord, the prosecution will lead evidence. My Lord, the asset declaration form are also in the proof of evidence, we annex them to the proof of evidence.